Ladies and gentlemen, all stand, please. The Federal Court of Australia is now in session. Please be seated.
Call the matter for determination, please.
Proceeding WAD 45 of 2012. Jaru People Native Title claim for consent determination.
I'll take appearances, please. Thank you, Ms. Toohey.
Yes, Your Honour, Ms. Begg for the State of Western Australia.
Thank you, Ms. Begg.
Your Honour, Ms. Watts for pastoral respondents.
Thank you, Ms. Watts. Now, Ms. Toohey, I understand you have some submissions to make.
Thank you, Your Honour.
The Federal Court has convened here today at Mary Pool to hear and determine an application for a determination of native title made on behalf of the Jaru people by Barbara Sturt, Peter Ween, Desmond Johnson, Leslie Whippy, Tim Crambrell, Barbara Cox, Deborah Gordon, Ross James, Kimberly Baird, Georgina Yeager, Bonnie Edwards, Nina Tesling, Roger Sturt, Edward Smith, and two other people who have sadly passed before this occasion, but who are remembered with respect and high regard. The land to which this application relates is governed by law of the Ngarrindjeri. The Native Title Act empowers the Federal Court to recognise the rights which are held by the Jaru people and come from the Ngarrindjeri, and make these rights part of the law of Australia, protected by the common law and statutes. The applicant, with the consent of the other parties to the proceedings, requests that the Court makes the orders as set out in the Minute of Consent Orders. Consent determinations in native title are increasingly common and occur when all parties work together for the common goal of recognising the rights of common law holders, which have been passed down to present generations from past generations since time immemorial. The Jaru consent determination is no different. It's before the Court today because of the commitment of the Jaru people to have their traditional ownership of country recognised by the common law of Australia through the process provided for under the Native Title Act. It is before the Court today because of the commitment of members of the Jaru claim group to provide their personal histories as evidence in support of a claim that will benefit all Jaru people now and into the future. It is also before the Court today because of the commitment of respondent parties, in particular the State of Western Australia, the Shire of Halls Creek and pastoralists, to a process and outcome that has led to the recognition of Jaru people's enduring connection to their country without the need for an adversarial contest before the Court. The matter is also before the Court today by consent because of the assistance provided by the Federal Court, in particular Judicial Registrar Herman, Judicial Registrar McGregor and Senior Case Manager Natalie Thomas. The Court convenes today at Mary Pool, which is on the western side of what will be the Jaru determination area. The applicant would like to thank the Court and Court staff for meeting here at Mary Pool to hear and determine this application. The practice of on-country determinations of native title is costly, time-consuming, logistically challenging, appropriate, respectful and deeply appreciated. Thank you, Your Honour.
Thank you, Ms. Toohey. Yes, Ms. Begg.
Thank you, Your Honour. Your Honour, the State has filed 3 documents on the 26th of November 2018 in court. A Minute of Consent Orders, which have been signed by all parties to the proceeding, a Minute of Consent Determination of Native Title, and joint submissions on behalf of the applicant and the State in support of the Minute of Consent Determination. For the reasons set out in the joint submissions, the State submits that the proposed determination is within the power of the Court and that it would be appropriate for the Court to make the proposed determination of native title. I would also like to acknowledge on behalf of the State of Western Australia, Jaru elders past and present, and to congratulate the Jaru people on the recognition of your native title today. Thank you, Your Honour.
Thank you, Ms Begg. Yes, Ms Watts.
Your Honour, on behalf of pastoralists, I confirm support for the consent determination. As part of the consent determination negotiations, the pastoral and JARU reached agreement on pastoral ILUAs that include best practice access guidelines that provide for coexisting access and recognition of pastoral interests as relevant interests in the determination area. To perfect the agreements, pastoralists look forward to the JARU nominating their PBC and taking control of their native title rights. Pastoralists congratulate the JARU on this momentous occasion.
Thank you, Ms Watts. The court will now pronounce the orders of the court. 1. It is satisfied that an order in the terms in the determination of native title in attachment A is within the power of the court and is appropriate to be made pursuant to section 87 capital A of the Native Title Act 1993 Commonwealth. 2. There be a determination of native title in the terms of the determination of native title in attachment A. The determination is to take effect immediately upon the making of a determination under section 56 subsection 1 or section 57 subsection 2 of the Native Title Act, as the case may be. 3. Insofar as WAD 45 of 2012 relates to the area of land and waters covered by Reserve 28538, WAD 45 of 2012 is dismissed and no determination is made in relation to the land and waters comprised in that area. 4. Within 12 months of the date upon which the orders are made, a representative of the common law holders of the native title rights and interests shall indicate whether they intend to have the native title rights and interests held in trust, and if so, by whom. They are to do so by A. nominating in writing to the Federal Court a prescribed body corporate to be trustee of the native title rights and interests, and B. including within the nomination the written consent of the body corporate. 5. If a prescribed body corporate is nominated in accordance with Order 4, it will hold the native title rights and interests described in Order 2 in trust for the common law holders of the native title rights and interests. In the event there is no nomination within the time specified in Order 4, or such later time as the court may order, the matter is to be listed for further directions. 7. There be no order as to costs. I publish the orders and the reasons of the Federal Court. The JARU people now have their native title recognised. Congratulations. I propose to say a few words and then we will hand out copies of the determination to the members of the applicant and people who are representing members of the applicant who have passed. I'm going to try some JARU, so sorry if I get it wrong, all right? Naja Nanya, Judge Mortimer. Binari Nyunyuna, Jaru Nura. It's a great privilege to be here on beautiful JARU country and to be here at Mary Pool. This day has been a long time coming for the JARU people. I am sorry that it has taken so long and that some old people have not lived to see this day. I pay my respects to all the elders who have not lived to see this day, but whose knowledge and experience and determination was very important in getting these orders today. I have been told the following elders who have passed away made an important contribution to getting this JARU claim through. The late Mr. J. Gordon, the late Mr. F. Timms, the late Mr. H. Boomer, the late Mrs. M. Butcher, and the late Mrs. P. Thomas. I also pay my respects to those elders still with us who have been very important in getting this claim through. Tanba Banks, Tomato Gordon, Kenny Boomer, Barbara Sturt, Flora Archu, Stuart Morton, Frank Sampi, Margaret Taylor, Marlene Turner, Doreen Turner Mosquito, Rosemary Mosquito, and Mervyn Street. You have, and every member of this claim group and every member of these families, you have been dedicated and patient, and you have pressed on with this claim despite the obstacles, despite how long it has taken. You have been strong. The Jaru people have been strong through this. I have heard of some of the important places on Jaru country that now that your native title is recognised, you will be able to protect better. Places such as Darlan, Garran, the important Sturt Creek waterway from Red Rock to Jawal Pool, to Bindi Bindi, up to the Kulia Jaru Banana Springs, to Jumbat, to Namarul, Marala Gorge, and all their associated dreamings. I also want to mention the many families who make up this claim group. Turner family, Banks family, Brandy family, Button family, Nyungkaja family, Thomas family, Linnott family, Birrell family, Jingle family, Weeby family, Thompson family, Ryder family, Yarlut family, Smith family, Hamilton family, Duncan family, Sturt family, Taylor family, Gordon family, Stretch family, Bedford family, Scott family, Cox family, Brockman family, Butcher family, James family, Manning family, Howard family, Rogers family, and the Mosquito family, and any other families. I'm sorry if I have left your names out. All these families need to work together through their PBC to care for this country and to see how native title can be of benefit for the Jaru people. I know there have been some differences and disputes. I'm sorry about that. I encourage you to find a way to work together and talk through your differences in the Jaru PBC. Native title can help your community, the Jaru people, control your own future. Native title can give you a base for the projects you choose, not that somebody else chooses for you. The native title system is hard. I acknowledge that. It is not perfect, and you must cope with a system of law that is very different to your own system. But for the moment, this is the only system we have to work with. Through the court's orders, Australian law recognises what the Jaru people have always known, that this is your country, that your connection to it is strong and enduring, and that your traditional law and custom has survived against all the odds and in spite of all the oppression that you have suffered since white settlement. The court acknowledges the important role of the state of Western Australia and the important role of the KLC. I would also, and the pastoralists and the Shire. I would also like to thank Judicial Registrar Herman for her work on this claim, and Judicial Registrar McGregor and Ms Natalie Thomas from the court. Thank you for coming. Thank you for your hard work and your commitment to see this process through for the sake of your people, the Jaru people, for the sake of your elders, for the sake of your young people and the leaders coming through, but most of all, thank you for the sake of your country that you have seen this through. Thank you very much. The court will now hand out the determination copies to those applicants.
Thank you. Ladies and gentlemen, I'll just call Mr. Albert Cox to assist with the handing out the documents.
Mary. This is the name applicant for the Java was for the Java claim. Georgiana Gira. Mr. Kim Giberg. Okay. Leslie Webby.
Congratulations, thank you very much.
Barbara Cox. You see me? You're right, okay?
Another one, India, from Peru.
Ms. Deborah Gordon. Edward Smith.
That's what they're saying us.
Ross James.
Mr. James, congratulations.
I don't know if the other applicants are here. Barbara Sturt. It looks like your son David's going to come and accept it on her behalf.
Thank you, Mr. Sabah. Thank you.
Peter Wayne. Yeah, Margaret's going to come and collect on behalf of Peter. Desmond Johnson. Anybody want to come and get her on behalf of Desmond?
Mary gonna get it?
Yes.
We're going to hold it.
I'll get it.
Mr. Vincent Skin. Thank you. Timmy Crandall. Anybody want to get it for Timmy? I guess I'm going to take it back this afternoon to Petro. Bonnie Edwards. Bonnie's son, number. Nina Chesley. She's probably in Brew. She's from Brew. Well, I guess we can give it back. Give it to her when they go back. Roger Sturt. You're going to get it on behalf of Roger Balma? Or Bonnie? No. And there were two other people who had passed sadly before this occasion, but who are remembered with respect and high regard. Thank you.
Right, ladies and gentlemen, we'll now close the court, and then I think there's going to be some speeches.
This court is now adjourned. I would like to call on Albert again to kindly consent to be the MC today, to call on the speeches. Thank you.
And we have some invited guests. First off, we'll invite to the front Ms. Sarah Carbonell. She's the Principal Policy Officer, Revenue Policy and Coordination Unit with the Australian Department of Premier and Cabinet.
On behalf of the State of Western Australia, I'd acknowledge all the Jaru people who are here today. I acknowledge the elders, the past elders, the present elders, and I know there are some who can't be here today, and I acknowledge them too. Thank you for welcoming us here today. I also acknowledge the Honourable Justice Mortimer of the Federal Court. Unfortunately, the Minister for Aboriginal Affairs, that's Honourable Ben White, he couldn't be here today. He sends his apologies. He would have really liked to have been here, but I'm really happy to be here to celebrate with you today. From today, as the judge said, Australia's legal system recognises what you've always known, that this is Jaru country, recognises a strong connection that you, as the native title holders, have and always have had to this land. West Australian Government looks forward to building a strong relationship with you and working through your PBC and talking about how we can work together on your aspirations for the future. So congratulations, and I thank you very much for the opportunity to be here today. Thanks.